Now, I want to present about the purpose of Employment Act 1955. The first purpose is to provide a number of minimum benefits for those workers covered by the Act. The Act is only applicable to employees work in West Malaysia with no age level. The month wages of employee does not exceed 1,500 ringgit. And the second purpose is to establish certain rights for both employer and employee. The obligation or responsibility they are obliged to fulfill or to have the legal protections. And this can improve work satisfactions of employee and also can meet employee health and security requirements. Now, I want to present about the objective of Factory and Machinery Act 1967. The first objective is to provide for the control of factory with respect to matters relating to the safety, health, and welfare of persons therein. This can prevent from any occurrence of accidents due to use and handling of machines in factory. The factory must provide standard minimum requirements the protections of worker safety. And it also can prevent the occurrence of disease due to excessive use and exposed to submineral dust and noise. And the second objective is the registrations and inspections of machinery and for metal connected therewith. Some high-risk machinery such as boiler and higher pressure vessels, passenger lift, and other lifting equipment such as mobile cranes, tower cranes, passenger hoists, and other must be certified and inspected by Department of Occupations Safety and Health DOS. All factory and general machinery must be registered with DOS before they can be installed and operations in Malaysia.
Hi, I am going to introduce on the Employment Act 1955, or known as short as EA 1955. EA 1955 is an act that is used to protect employers and also employees' benefits in the work field. The Act enshrines the rights of both employees and employers and the obligation or responsibilities they are obliged to fulfill to have the legal protection. EA 1955 applies only to Peninsular Malaysia, which includes Federal Territory, Wilayah Persekutuan, and Labuan. For East Malaysia Territory, like Sabah and Sarawak, employees and employers are covered with Sabah Labour Ordinance for Sabah and Sarawak Labour Ordinance for Sarawak. The latest revision to EA 1955 was done in the year 2012. EA 1955 is also known as Act 265. EA 1955 can be basically found in the statutes as Parliament-made law or Act of Parliament, such as Industrial Relations Act 1967, Holidays Act 1951, Employees Social Security Act 1969, National Wages Consultative Council Act 2011, as well as in subsidiary legislation under the Employment Regulations 2010, as well as case laws that refer to judicial precedents found in law reports for similar cases to be treated alike. So, who is entitled for this law? So, employees with the monthly salary of less than 2,000 ringgit, employees that are engaged in operation or maintenance of mechanically propelled vehicle, employees who are engaged in manual labor regardless of salary, employees who supervise other employees that are engaged in manual labor, and also employees engaged in any capacity on a vessel. So, there is employees that are covered in the Act EA 1955. There are also employees that are not covered under EA 1955. For example, are domestic workers and also substituted workers. In terms of the rest day and work day of employees, the employees are entitled to one whole day of rest day in each week without deduction of salary. Any employee that is required to work on a rest day must be paid additional wage of 1 day at this ordinary rate of pay. For overtime, the wages are as above. So, if it is on a normal days of work, the overtime wage will be 1.5 times the hourly rate of the pay. On a rest day, it will be 2 times the hour rate of the pay. For a public day work, it will be 3 times the hourly rate of pay. So, in terms of deduction of pay, employers are only allowed to make deduction if there is an overpayment of wages due to mistake that is made by employers. Deduction of payment in lieu of notice where the employee resigns without serving full notice that is needed when signing the contract, as well as deduction for recovery of advances of wages, and also deduction authorized that is authorized by any other written law such as EPF, SOCSO, and income tax deductions. So that is all with the introduction of EA 1955.
Next, the introduction of Factory and Machinery Act 1967. Factory and Machinery Act 1967 or Act 139 are an act with matters relating to the safety, health, welfare of persons and the registration and inspection of machinery. The purpose of this act is to provide control of factories and prevent occurrence of occupational accidents and disease at specified workplaces. The FMA 1967 was approved by the Parliament of Malaysia in the year of 1967. The FMA 1967 will cover all occupational safety and health in the manufacturing, mining, quarrying, and construction industries, whereas the other industries are not covered. It covers 23% of workforce. The high-risk machinery, such as boilers and fire pressure vessels, passenger lift, and other lifting equipment, must be certified and inspected by Department of Occupational Safety and Health (DOSH). All factories and general machinery must be registered with DOSH before they can be installed and operated in Malaysia. There are 17 regulations most enforced under the FMA 1967, which is 11 safety regulations, 4 health regulations, and 2 amendments.
Next, Employment Act 1955. There are 21 parts and include with 103 sections. First of all, Part 1 is preliminary. There is 5 sections. Continue with Part 2, Contract of Service. Continue of Part 2. There are 9 sections till 17A section. Then, Part 3 is Payment of Wages. Section 18 till 23 section, which is wages not due for absence from work through imprisonment or attendance in court. Then, Part 4, Deduction of Wages, which is section Lawful Deduction. Part 5, System of Payment of Wages. Part 6, Parity of Wages. Continue Part 7, Contractor, Principals and Contractor for Labor. Part 8, Employment of Women. Part 9 is Maternity Protection. Part 10, Employment of Children and Young Persons. Part 11, Domestic Servant. Part 12, Rest Day, Hour of Work, Holidays and Other Conditions of Service. Next, Section 13, Termination, Day Off and Retirement Benefits. Part 14, Employment of Foreign Employees. Part 15, Register, Return and Notice Board. For Part 15 is Inspection. For Part 16, Complaint and Inquiries. Part 17, Sexual Harassment. Part 18, Procedure. Part 19, Offense and Penalties. Part 20 is Regulation. Next, final one is Repeal and Saving.
Next is about the sections in Factories and Machinery Act 1967, and this act is contained 6 parts comprising of 60 sections. For the first part is about the beginning. It contains 9 sections. Section 1 is short title. Section 2 is definitions of factory. Section 3 is interpretations in general. Section 4 is appointments of officers. Section 5 is supervisions of officer. Section 6 about the officers in a public servant. Section 7 power of an examiners. Section 8 is barriers to an offense, and Section 9 is a person who cannot reveal secrets. Part 2 is safety, health and welfare. It contains 60 sections. Section 10 is provisions related to safety. Section 11 is people exposed to explosive and flammable. Section 12 is lifting heavy object. Section 30 is preparations for fire. Section 40 is constructions of machinery. Section 50 parts of hazardous machinery. Section 60 projected material. Section 70 machinery for rent or sale must comply with regulations. Section 18 is machinery made or repaired must comply with regulations. Section 19 is certificates of eligibility. Section 20 is duty of employed person. Section 21 duty of occupants. Section 22 is provisions relating to health. Section 23 is disclose of elements. Section 24 clothing and personal protective equipment. Section 25 that allocations related to virtue. Part 3 is person in charge and certificate of competency. It contains 5 sections. Section 26 is training and supervision of inexperienced workers. Section 27 chief inspector may make order in certain circumstances. Section 28 young people. Section 29 certain machinery cannot be operated without certified staff. Section 30 is panel of examiners and the board of appeal. Part 4 is notifications of accidents, dangerous incidents and dangerous disease. It contains 3 sections. Section 31 is accidents and dangerous incidents should be reported. Section 32 is notifications of industrial disease. Section 33 is investigations. For Part 5 is the factory occupancy notice and the registrations and use of machinery. It contains 30 sections. Section 34 is factory operation. Section 35 is operations of building or engineering constructions work. Section 36 is installations of machinery. Section 37 is applications for registrations. Section 38 is register. Section 39 is transfer or alterations or additions to machinery must be approved. Section 40 is periodic inspections. Section 41 is questions to be decided by the examiners and appeals from the decisions. Section 42 is reports on exchanges. Section 43 is unused machinery or factories. Section 44 is notice of sale, lease and transfer. Section 45 is copy of the investigations report may be supplied. Section 46 is powers of the chief inspector and senior examiners during the investigations. Part 6, which is general. It contains 40 sections. Section 47 is untouched criminal or civil liability. Section 48 is fees. Section 49, power of chief inspector. Section 50 is offences. Section 51 is penalty. Section 52, prosecutions. Section 52A, power to compound. Section 53, power to modify agreements. Section 55, power to allocate expenses. Section 55 is exemptions. Section 56 is regulations. Section 57, medical supervisions. Section 58, repeal. And the last section is sections 59, amended of the schedules.
Hi, so today I'm going to discuss about cases involved and case studies related to law issues for the Employment Act 1955. First of all, I'm gonna discuss more on the first case is Brindle v. Smith, which is when dismissal is by way of notice. The date of dismissal is the date on which the notice expires, and this is unaffected by the circumstance that the employer waives his right to the employee's services during his time. For the second case, Liz v. Arthur Greaves, on year 1974, Liz v. was dismissed on 1st October 1971 with 6 months' notice. It was arranged that he should work out his notice until 31st March. For the third case, it is Company du Campoche, Clare Estate, Ja'a v. Boy Kanama, alias Nadaraja, and Ors on 2006. The first respondent was a vendor and the rest were rubber tapers employed by the Clare Estate, owned by the appellant. On 31 October 1995, the appellant gave them 8 weeks termination notice to take effect from 1st January 1996. However, some 40 days before 1st January 1996, the appellant withdrew their termination letter. For the fourth case, it is the Karisna Anak Lelaki Govindasamy v. Highlands and Lowlands, Ladang Bukit Selarong, on 2003. The appellant worked with the respondent as a foreman. By a termination notice dated 1st November 1998, the respondent informed the appellant that his employment would be terminated with effect from 1st January 1999. The reason given for the termination was that the respondent had decided to replant its rubber plantation with oil palm. Regarded the termination notice as effective, the appellant did not turn up for work from 1st January 1999 onwards.
Next, we move on to case studies related to legal issues for the Factory and Machinery Act. From the title, the topic that I will mention will be under DOSH enforces the Occupational Safety and Health Act 1994 and Factories and Machinery Act FMA 1967. However, I'm going to focus more on FMA 1967. There are several cases or issues that I found from news or website. So first of all, a factory worker from Sabah who sustained injuries after the machine he was handling exploded. The second one is an Indonesian construction worker was killed and 3 other migrant workers were injured after being hit by a falling construction crane in Shah Alam. And the last one is the pollution of Sungai Kim Kim is because of the irresponsible from factory. Because of these cases, what things need to do for the employer and employee? Numerous accidents at the workplace, which more often than not occur due to the employer's failure to comply with occupational safety and health regulations. The employer and the employee must be proactively involved in the occupational safety and health issues at the workplace. As long as the employer and employee follow all the instructions given by the inspector, they are adhering to the law. In my research, I found 2 case studies related to Factory and Machinery Act. So for the first one is Study of the Occupational Safety and Health Law in Malaysia by Siti Zahara Jamaluddin, and the second, Report on Health and Safety Workplace Case Studies by Heathrows Research. From Siti Zahara Jamaluddin's study, she related with the emphasis of the Act is on the establishment of factories and the use of machineries in those factories. She also mentioned that the employer must provide for personal protective clothing and appliances for workers who are exposed to a wet or dusty process, noise or heat, or any poisonous or corrosive substance in accordance with the guideline provided by the Minister. Overall, the Act was based on a traditional checklist system whereby the hazards are identified and measures to overcome them are stipulated. The second case studies is by Heathrows Research. She mentioned that any accidents, incidents, and near misses are identified using the tick and flick method incorporated in the daily task sheet. Any incidents are reported by the team leader using an incident report form. She also mentioned that any accidents are subject to an internal investigation within 7 days, with responsibility for this being with the manager responsible for the area in which the accident occurred. In determining corrective actions, there is an expectation that the 9 basic that he or she mentioned causes are also used to identify immediate causes such as updating training, fitting machine guards, and basic causes such as system or management failures. As a conclusion, Malaysia is certainly on the right track in effort to create a safe system of work for its workers by enacting the Factory and Machinery Act 1967. The provisions of the latest act signal the readiness of the government to allow the employers to decide for themselves as to the safety measures required for their organizations. A more significant role must be played by the employer and the employee in ensuring that the place of work is safe.